Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another exciting episode of our show. Today, we are talking to Mark Abell of Mark Abell Law Offices. He is a litigator as well as dealing with estate planning. Mark, welcome to the show.
Thank you. So glad to be here.
It's a pleasure to have you. And I'm going to start off by saying that you have like one of the best domain name that I've seen for attorneys. So I'm just going to do a quick plug. Trustabell.com.
Yeah.
Beautiful. Such a good name.
Wish I could take credit for it, but my wife came up with it. So.
Yeah, that's usually the best ideas always come from the wives. Okay, Mark, let's delve right into our show. So what I wanted to talk to you about, it's kind of like the fine line between the estate planning and the litigation process. So my first question to you is, when crafting an estate plan, how do you put in place things that will help you down the line avoid litigation? What are some of those things?
Yeah. So if somebody's coming to talk about forming an estate plan, it seems like most generally one of the main concerns that they have is avoiding any type of probate. And
Right.
a probate might not necessarily be a litigated issue. It's just simply a process of going to court. But a lot of
Right.
people don't want to deal with it. They don't want to deal with the time, the
Right.
expense, the hassle of dealing with it. So if they're coming to do an estate plan, they already know that they want to avoid that process.
Mhm.
And what can make that even worse is if the estate gets wrapped up in litigation. And there's
Mhm.
different types of litigation that you can actually have involving estates. You can have litigated issues regarding whether an individual was in even the right mindset
Right.
to execute an estate plan. So it could be like a conservatorship issue. You
Mhm.
can have a litigation over whether the probate is being administered properly, or you can have an issue regarding trust administration, which is largely outside of the court system.
Right.
There's issues regarding whether the trustees acted properly or things like that. So in general, what we want to do is we want to tell them to just make that people have a basic idea that they know that they've created an estate plan, so they know in general terms what to expect. Now, I don't want them telling the specifics because plans change,
Right.
issues pop up and things like that. But as long as generally people are on the same page and they know that there's what to expect, it can actually stave off a lot of the issues further down the road.
That makes total sense. Thank you for explaining that. Now, let's take these things one at a time, because everybody's, I won't say everybody, but a lot of people are familiar with the no contest clause that you put in an estate, in a trust.
Sure.
If somebody, for our audience, they should be familiar with it. But if they're not, if some of the beneficiary contest, they become disinherited. That's the clause. Unfortunately, that doesn't work if you already are disinherited. That's not an incentive, or if you get very little. So I wanted to basically ask you, what other mechanism do you think that can be incorporated in a trust to protect the estate? I know it's impossible to say, this is litigation proof, but what other thing can you put in there to make it even tougher to litigate?
Yeah, well, you really did identify the issue. So with respect to the no contest clause, there's different, I would say maybe like levels of thoroughness that we can include within a no contest clause. So you can basically have like an entry level one, you could have one with more substance to it, and then you could basically have an even larger one. So we can tailor each individual clause to whatever the client wants with respect to various scenarios. Another thing that we can do is we can put in place what's called a trust protector, which is
Okay.
another individual who is nominated in a position in a trust to basically make sure that the trust is carried out pursuant to the terms. It's been kind of something that people have been adding now for a while and is gaining some traction. And then another thing that we can do too is there's two basic theories, basically, I guess the carrot and the proverbial carrot and the stick. Instead of totally punishing somebody, you can also incentivize them to a certain
Mhm.
extent. So if there was some type of issue that created a falling out, you can incentivize within the trust that those issues be resolved in order for them to actually get the inheritance. And that may have some type of therapeutic effect, I guess,
Mhm.
later on, based kind of incentivizing that individual to act in a certain manner so that way they can obtain something. So
That makes sense. Thank you. Thank you for adding those things. I believe that a trust protector is not something that a lot of people know about. So thank you for talking about that. So, a lot of the litigation, and we'll get to the competency factor in a minute, because I feel that a lot of the litigation that people deal with when it comes to estate planning is to how things are run. People are like not happy with the trustee, not happy with the executor. Things are not going the way they should. So we are going to litigate. So in that respect, how do you advise your client when it comes to selecting a successor trustee or an executor? What are the things that you say, okay, we got to keep these things in mind so that, basically what type of individuals, because I know that the answer is always like our adult, our oldest child, things like that. But when that, is not an option, what are the things how do you guide your clients?
yeah, so we typically want to have somebody that has some familiarity with the duties that the role entails. And
Hmm.
so a lot of people just basically say, oh, well, I want someone to run my estate, like you said, the eldest child, whatever it may be, but they don't
Right,
necessarily take into consideration what they're actually asking that individual to do. And
right.
so the role of the trustee or an executor requires marshaling assets.
Hmm.
Okay. So they need to be able to have the ability to deal effectively with, real estate agents, banks, insurers, title companies, things of that nature, attorneys. They need to have some familiarity with accounting because
Hmm.
all of the money that comes in and all the money that goes out needs to eventually be accounted for and distributed properly. And
Hmm.
they also need to have the ability to manage, family dynamics, right?
Right,
The ability to say no, the ability to say yes, the ability to
right.
kind of manage conflicts before they escalate. And so if they don't have somebody that, necessarily is able to wear all of those different type of hats, so
Hmm.
to speak, then we might nominate somebody that is called a professional private fiduciary.
Right.
Okay. These are individuals that actually have training in doing this. Their job is to essentially run trusts, run estates, things
Mhm.
like that. They're usually bonded, they're usually insured, and they usually have a lot of experience doing this. And so they have kind of the infrastructure set in place that would allow them to effectively carry that out and manage it, as opposed to somebody that is just trying to do it basically as the issues arise and has never done it before. So
That makes total sense. That's great. You anticipate. I was going to ask that. My next question was was a follow up. Was going to be, when do you get a professional fiduciary? And I think we slid right into it, and that's perfect. Now let's talk about the competency thing. Something you mentioned at the beginning of the show. When competency is an issue, or what I should say, when it can be questionable. When that somebody may question, they come to you, they say, "Okay, Mark, my dad, I need to do the trust, da 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 da," and you meet the trustor, and you're like, hey, this, I don't know, he's 95, who knows what may happen to us. So when that situation arises, what are the steps that you take to kind of ensure that does not become, it can always be contested, but that it makes it more difficult to be contested down the line?
So obviously, every situation is going to be different. Just in general terms, some of the things that attorneys might want to consider when they're doing this is that, obviously meeting with the individuals face to face and for an extended period of time is important, I believe, because that way you can get a greater sense of the individual's capacity. Some things that one might want to consider just in general terms are if there is a doubt as to an individual's capacity, is contacting another attorney.
Hmm.
And you could have an independent attorney also evaluate the individual, and they would prepare what's called a certificate of independent review. So then instead of just having one individual evaluate the person, then you would have two. And then also in some other instances, you may want to have a geriatric psychiatrist come in and evaluate, but that would probably be, not as common, I would say, as in most cases. But there's just a lot of different things that you could do, and obviously the doctor would have a higher level of understanding and training than someone else probably would. So
That makes total sense. Let me ask you another question related to, a lot of people that come and do estate plannings with you, I feel like people who are proactive into it, they also have, a desire for privacy in a sense in regard. That's why, we don't want to do probate because that's kind of like in the public eye, everybody knows what's going on. So how do you balance, from somebody maintaining privacy as well as having to share some information with the family? What is the appropriate amount of information that somebody should share? And how do you approach that conversation with somebody who's doing estate planning with you?
Yeah, no, that's another great question. So obviously, anytime that I talk with my clients, it's governed by the attorney-client confidentiality and privileged. So we never disclose anything. The trust documents do keep things private. They keep it out of probate, and we do create a sort of certificate of trust or a certification of trust or a privacy affidavit. Those documents would essentially allow the individuals that created the trust to deal with third parties and other entities without disclosing the specific terms of their trust documents. And so basically what I tell in general terms is that, this is your estate plan. You don't need to disclose it to anybody. We do generally say it is a good idea to let people know that you have created an estate plan so
Right.
that people don't just run down and try and open up a probate
Hmm.
unaware that any type of estate plan was put in place. But aside from that, I basically let the clients determine what level of privacy or disclosure they feel is comfortable for them and in their best
Hmm.
interest. So, I mean, it's their estate plan, and they don't need to disclose anything if they don't want to. Whereas other people say, hey, everybody knows what's going on anyways, and it is what it is. And so it's whatever that their level of comfort is. So.
That's interesting. Let me ask you a question related to this. And there are different philosophies about this, but when you nominate a successor trustee, do you feel that this person should be aware of the fact that they've been nominated successor trustee?
Okay, yeah, so that's interesting. I guess there are different schools of thought on that. One thought being is that you don't want to have somebody totally blindsided by it and unprepared
Right.
for it, and then potentially reject the nomination.
Hmm.
Then you'd have a vacancy and go to your successor. The other school of thought is that this is a living, changeable document,
Hmm.
and that, hey, I might want them here today, but maybe not tell them that because maybe I'm testing them out or something like that to see
Right.
how things work. And I can always change it at a later date. And I don't want to have somebody anticipating something at a later date that I've subsequently changed. So I basically, I tell my clients both of that, and let them decide for themselves whatever they feel is best. So
That makes total sense. I'm actually going to share a funny story of an attorney. Attorney clients are, when they are. I remember seeing a document that they had filed with the about the successor trustee that had been crossed out in pen like 10 times. Like they changed like 10 times. It was the person who was the successor trustee. So
oh,
some of these things can get a little messy, but
yeah.
um, you know okay, let's talk about the litigation aspect of your practice. And so my question that I wanted to ask you is, can you share with us some examples when your practice had to deal with estate litigation, and how you prepared your clients for that?
Yeah, so just I don't discuss any pending litigation,
Of
ongoing
course.
past cases or anything like that necessarily, but just in general terms, litigation can be a difficult situation
Hmm.
to be involved in general terms.
Right.
And especially, I think the probate litigation, the trust litigation makes it even more so, based
Right.
on the fact that the clients are typically already going through a traumatic experience of losing a loved one, maybe,
Hmm.
or something like that. And then they're also now typically in the traumatic experience of dealing with difficult family situations as well. So
Yeah.
they're just, bear that in mind as we go through the litigation process with everybody, because I think it tends to make there's a lot more, I think, emotion maybe
Yeah,
going
that
through
makes
some.
total sense. That makes total sense. Mark, let's talk about your journey. This is always, something that fascinates me. Did you want to be a lawyer when you were a kid?
So it was funny. I was just kind of talking with my wife about this Halloween. I didn't think I did, and then I
Hmm.
kind of had this memory when I was younger. Actually, I was one of my costumes. I remember I was like wearing a suit or something. I think I had like a face and everything like that. So on some subconscious level, maybe I think I must have, but kind of through the ages, I don't necessarily remember it being as like the one job that I thought I wanted. So it more so developed when I was in college and I majored in philosophy, and it just felt like the next logical choice to go to law school as
Hmm.
opposed to continue on with the PhD and so,
Right.
whatever. So
That makes sense. Now let's talk about the specific areas of practice that you have developed. When you were in law school, did you know what you wanted to practice? Did you have an affinity for a specific area over another? Or were you kind of like, I'm going to try a bunch and then I'll see where things go?
yeah, in law school, I actually didn't know that I took some estate planning courses in law school, some probate
Mhm.
courses, real estate courses, obviously, which this area now governs all of those. And I did
Mhm.
know pretty early on that this was kind of the area that I wanted to focus on, I think. So,
That's great. So when you got out of law school, you kind of started essentially practicing what you practice now.
yeah, that would have made sense probably.
Mm.
But actually, I ended up, when I got out of law school, working on for a plaintiff's firm, construction defect litigation. And
Got
then
it.
after that, then I worked for a plaintiff's firm doing asbestos litigation. And
Okay.
so that's where I basically honed my litigation skills. And I also volunteered for a brief period of time to get some trial experience in LA County. And then after that, then I opened up my own office and basically focusing in estate planning and the trust and probate litigation from there.
Very nice. Thank you. Thank you very much for sharing that with us. There's a way I like to end all my shows with. I have 30 questions that are, I won't ask them all, but I want you to pick a number between 1 and 30,
Okay.
and I will ask you that question. So go ahead, pick a number.
Okay. Let's say, what is it? The 15th? We'll pick 15 today.
Great. If you could have one superpower, what would it be?
Oh my gosh. You know what? I was just watching The Incredibles with my daughter, and Frozone's power looks pretty awesome. So yeah.
That's awesome. Very nice. Before I let you go, one more thing. It's what is the best? We're going to have your contact information in the show notes, but what is the best way for people to get a hold of you if they need estate planning or anything related to litigation and estate?
Yeah, either giving us a call, leaving a message with our assistant. They'll be happy to reach out to you and set up an appointment, or sending an email. Also, we respond to those as well. So,
Great. And once again, trustabel.com. Awesome website. Go
thank
check it out. Mark, thank you so much for being on the show. It's been such a pleasure.
likewise, thank you for having me. I really appreciate it.
Okay, everybody, we'll see you on the next episode. Bye.
Thank you.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020547763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.